Welcome to our presentation on the parts of a general civil hearing in Texas. This video is sponsored by the Texas Bar Foundation. Thank you for your support. Whether you are going through a divorce, custody dispute, protective order, or other types of civil case, knowing and understanding the process of the hearing beforehand is crucial. This information in this presentation does not, and is not, intended to be legal advice. Instead, all information, content, and materials available on the site are for general information purposes only. Viewers should contact an attorney to obtain advice with respect to any legal matter. In this video, we will be going over different sections of a hearing: opening statement, direct testimony, cross-examination, and closing statement. At trial, each side will have a chance to make opening statement. This statement can either be given by your attorney or by yourself if you choose to represent yourself in your case. Your opening statement is like a preview of your case. It should briefly outline your general legal position. Your opening statement might refer to your evidence, but the opening is not the time to present your evidence. When it is your turn to speak, please tell the judge, "Your Honor, I'm ready to proceed." Here are a few key tips when giving an opening statement. Tell a story that they will remember and believe. Provide a theme that will serve as a framework for every piece of evidence that will be heard during the case. Use simple, ordinary words and phrases. Use language that transforms actions and concepts into memorable images. Involve the audience. Keep your story organized and logical. Keep it short. An example of an opening statement given personally can look like this. My name is, and I am his wife. We have been married since 2021. We do not have children together, and none are expected. Throughout our marriage has been abusive towards me, and I am asking for a divorce based on grounds of cruelty. I'm here today to ask for divorce and to divide our property and debts in a fair manner. Additionally, I'm asking the court to change my name to maiden name. Generally, courts put witnesses outside of the courtroom before they testify. Any other witness may be told to wait outside where they cannot see or hear the hearing until they are caught. If that is not what happens, and there are witnesses, you will need to ask for something called the rule. This will mean that all witnesses will have to wait outside of the courtroom. This way, they cannot hear each other's versions of the facts and change their testimony. You should state to the judge, "Your Honor, I would like to invoke the rule." The judge might use this time to swear in all the witnesses, including yourself and the opposing party. At the time, and make your promise to tell the truth. Just raise your right hand like on television. This oath is important. Telling a lie in a court is called perjury and can result in a fine or even time in jail. Whoever files the lawsuit first usually has the opportunity to testify first. If you were the first person to file the case, this means your testimony will be up first following opening statements. If you are the respondent in the case, this means that you will have the opportunity to testify once the other party is finished with presenting their testimony and any witnesses they may call. When it's your turn to testify, the judge will ask you to raise your right hand and swear to tell the truth if you have not done so already. This is a serious moment. Your testimony is your chance to tell your side of the story. After taking the oath, you will tell your story. Keep it clear and to the point. The judge will be looking for facts, not opinions or emotions. The judge may ask you questions. If you don't know the answer, don't guess. Simply say, "I don't know," or "I don't remember." Honesty is always the best approach. Your testimony should explain what you want the court to decide and why. For example, you might say, "I'm asking that the court because..." During your testimony, you may also present any evidence you have to help support your story. Here is an example of testimony that you can use for evidence you would like to use for your evidence, such as your protective order. "Your Honor, Can I approach everyone to share Exhibit 1? Your Honor, this is Exhibit 1. Exhibit P1 is a photo that was taken on. I took this photo with my cell phone. My cell phone is capable of taking photos. This exhibit has not been altered in any way. I would like to offer Exhibit 1 into evidence. A few key tips. Speak slowly. Speak loudly enough for everyone to hear. Stay calm and always tell the truth. Think before answering each question and only respond to what was asked. With preparation and confidence, your testimony can make a strong impact. Once you've told your story, the judge will ask the opposing attorney if they have any questions for you. This is called cross-examination. This can feel intimidating, but remember, stay calm and answer truthfully. Keep your responses short and to the point. If possible, answer with yes, no, or I don't know. You can explain later if needed. Speak up so the court reporter can record your answers. Don't just nod or shake your head. Say yes or no out loud. If you don't understand the question, don't guess. Ask the attorney to repeat or clarify. If you think a question is unfair or unrelated, you can ask the judge, "Do I have to answer that?" If the judge asks why, you can say the question is irrelevant or already asked or answered. Try not to look at the defendant. Direct your answers to the judge instead. The judge might also have questions for you. Answer truthfully and address them as Judge, Your Honor, Sir, or Ma'am. When cross-examination is over, you may want to clarify something. You can say, "Your Honor, I would like to offer more direct testimony quickly to respond to those questions." If you don't have anything to add, you can say, "I have nothing further, Your Honor." Or, if you have witnesses to call, let the judge know, "I have a few witnesses I would like to call." Narrator cross-examination can be challenging, but stay calm, be clear, and speak the truth. You prepared for this moment, and your voice matters. Trust yourself, follow the steps, and take it one question at a time. You've got this. If you would like to call a witness, you may do so directly before or after your testimony. You should only call witnesses that you believe will add to your case. They will need to have been people that actually saw something or heard something directly that is relevant to the case. First, start off by letting the court know that you would like to call a witness. You can say, "Your Honor, at this point, I'd like to call as a witness." The judge will ask the bailiff to bring your witness in, and you can begin your questioning. Remember, the point of questioning witnesses is to get them to tell the court about what they have witnessed or heard. You will want to ask them open-ended questions to help prompt them in telling their story. Some examples of questions include, "Can you tell the court your name? What is your relationship to me? How do you know the opposing party? What do you know about the opposing party?" You can follow this similar format with your witnesses. Feel free to add questions if you feel they may help the judge understand why you are asking for the things you're asking for. The other party in your case will also have the opportunity to testify. During their testimony, make sure to write down notes or anything you may want to ask them about. Once they have finished testifying, you will have the opportunity to cross-examine the other party and their witnesses, if any. Cross-examination of an adverse party is when you get to question the other side and their witnesses. The goal is to challenge their testimony and bring up facts that support your case. Rules. You can only ask relevant questions, and you must follow the Texas Rules of Evidence. For a cross-examination, you are allowed to ask leading questions. For example, you can phrase your question to start with, "Isn't it true that," followed by whatever you want to ask. If the adverse party is lying in their answers, you can stop asking and tell the judge you have no further questions. Here are some tips. Ask short, clear questions, seeking a yes or no when possible. Stay calm and professional, no arguing. If the witness avoids answering, Politely press for a response or ask the judge to direct them. Attorney asked, "You said you always pick up your child on time, correct?" Witness said, "Yes." Attorney asked, "But in these text messages, you said you were running late 3 times last week. Isn't that true?" When you are done, you may tell the judge that you have no further questions for the witness. It is important to note that you are not required to cross-examine the other party or their witnesses. If you do not have questions for them, you can simply stand and tell the judge that you have no further questions for this witness. Closing statements are your final chance to tell the judge why they should rule in your favor. So here's what you want to include. Summarize key facts, including what the evidence showed. Explain why the law supports you. Mention Texas Family Code sections if helpful and relevant. Emphasize the best interest of the child if applicable. Stay focused and confident. Keep it clear and persuasive. An example of a closing statement may be, "Your Honor, the evidence clearly shows that I have consistently provided a stable home for my child. The text messages presented today show that the opposing party has not shown interest in understanding our child's needs. Texas Family Code Section 153002 says the court must prioritize the best interest of the child when making decisions about conservatorship. Based on the facts, I respectfully request the court award me sole managing conservatorship of our child." Our team at Texas Advocacy Project hopes this video was a helpful resource in better understanding the different parts of a general civil hearing in Texas. If you are in need of legal advice, please call us at 800-374-HOPE.